Bonsoir tout le monde, nous comptons avec aujourd'hui pour capable présenter une autre interview et sous dossier TPS, statut protection temporaire. Et jeudi, nous gagnons plaisir pour nous recevoir avec nous et Suzanne Church. Suzanne qui c'est et dans mon cap travail donc dans Massachusetts dans office réfugié ensemble avec immigrants et puis lycée chef opération donc et puis lycée avocat tout lycée conseiller juridique avec lui. Nous allons voir qui qualité ressources qui est disponible pour immigrants et puis qui les travaillé à expirer et vraiment et puis c'est une pile discussion qui a fait est-ce qu'il y a des possibilités après 27 juillet pour travailler continuer et nous allons voir ça ensemble avec Suzanne. Suzanne, bonjour, comment vous êtes?
Bonjour.
Good morning. So I'm glad you accept to talk to us about the resources that are available for immigrants in Massachusetts. The governor, Morale, put a statement recently sharing some guidance, what employers and employees should know about the TPS. Can you share with us what should someone with TPS right now working, what should they know, what should they expect right now?
Absolutely. And thank you so much for having me also. So in light of the Supreme Court's opinion, unfortunately, we do expect most likely that the TPS for Haitians will end on approximately July 27th, 2026. That is because the rules take effect when the Supreme Court certifies its actual opinion that they already issued. So they issue the opinion in writing, and then for some reason, 32 days goes by, and then the Supreme Court says, yep, this is the correct opinion. It's certified. And that's when it takes effect. So employers, number one, I want Haitians to know that nobody should be laying off Haitians who have TPS status until that Supreme Court opinion issues and it is certified that it is the decision of the court. Number two is just because someone previously had temporary protected status and the government has revoked that does not mean they are undocumented. So there are many other pathways for immigrants to obtain lawful status. One way is through asylum. I'm sure people are familiar with that. That requires a very experienced lawyer that you have not located by using TikTok or Instagram, okay? You need a real lawyer who has, and we're gonna provide you with some legal resources about that, including our new help desk. So one way you can find a reliable, trustworthy lawyer is through a new program we are announcing called the help desk. You will see on the screen here the ability to reach help desk. You can get it in 3 ways. One is to email, one is to go directly to the link, or one is to go to our website. On the help desk, you will be virtually connected with a trusted lawyer who can look at your case, determine if there are other pathways for you to obtain work authorization and a green card. If they find other pathways or suggest other pathways, they may even be able to help you start that process by filing an asylum application. But what I see in the community a lot are using people who do not know what they're doing, who are not immigration lawyers or experienced immigration lawyers, or not even lawyers at all. And those people ruin the case. They will ruin the case. There's a saying we say in America all the time, you get what you pay for. When you're using somebody who's only charging you a couple $100 to file an application, generally they're might be giving you a real problem, unless it's a trusted nonprofit.
So, Susan, given the time constraint right now, say that someone looking for a lawyer right now, how long it might take for them to get someone who would be willing, available to help them? Because there are people, they are saying, if you wait after the Supreme Court decision take effect, so it might be more difficult to prove your case because in order to file for asylum, you have to have legal status. So how long it might take for someone who contact the office right now looking for a lawyer to help, and then they have all their documents ready to submit the application for them?
So one thing to be clear, the rule about filing for asylum So there's a rule called a 1-year rule. Everybody's heard of this rule, right? Most immigrants have heard of it. And that rule is that you have to, quote unquote, file for asylum within 1 year of the day that you entered the United States. But that rule is actually not accurate when it comes to people who have been under valid TPS status. For those under valid TPS status, they are not required to do it within 1 year. They're required to do it within a reasonable amount of time after the expiration of TPS status. That reasonable amount of time is not defined, but I would suggest that people, if they do have a valid asylum claim and they speak with a good attorney who says you have a valid asylum claim, to do it within a very short time period of July 27th. I don't want to put an exact time frame on it because the courts have yet to fully define what a reasonable amount of time is. But I do think that clock is starting to tick as of July 27th as to what is a reasonable amount of time. You are not necessarily unable to file for asylum after July 27th. That's really important. Like, you need to go to a trusted lawyer, go on to the American Immigration Lawyers Association website, use our help desk, and they will assist you in the process of filing for asylum if you have a good claim. Our help desk has appointments available 4 days a week. So right now we have spots available. We just strongly recommend you set up that help desk appointment right away. The Massachusetts Access to Counsel Initiative, also, which you can find on the Miro website, they have a wait list for attorneys, but you can apply for an attorney for that through free legal services. But if none of those options work for you, we recommend reaching out to private attorneys also.
So is there a cost attached to these resources? Like, someone said that I contact you and then I'm connected with a lawyer to help me with my case. Would I have to pay for that?
So our help desk is free. And if you are qualified as an income eligible individual, it is also free to access the Massachusetts Access to Counsel Initiative. That phone number is 508-505-4588. But you have to be income qualified in that you don't make enough money to pay for a lawyer yourself. If you make enough money to pay for a lawyer yourself, you can reach out to the American Immigration Lawyers Association, and they can refer you to trustworthy immigration lawyers who you can pay to represent you.
Do you know the cap, like, they're not to be qualified, like how much someone could make, say they are able to pay for a lawyer themselves?
Yeah, so it's different for different programs. The help desk is free for anybody. We don't do income screening for the help desk. For the Massachusetts Access to Counsel Initiative, you need to make what's called 125% of the poverty guidelines or currently be receiving benefits in some form. So either of those would qualify you. 125% of the poverty guidelines for a family of four is usually about around $35,000 to $40,000 a year. So it's very low income.
Since you talked about if someone is receiving benefits, and the government right now, they put a memo just yesterday saying they might strip someone from their green card, or they might deny the green card application if someone is considered a public charge, like someone who is receiving food stamp, things like that, or have Section 8 or the government support, like federal government support. So is there any risk? Can you talk to us about that for someone who is receiving benefit right now? Would you advise them to trying to, be on their own? Obviously, some people might never be able to do because they are not working. But what can you tell us about that?
Yeah, great question. So the government announced, I think yesterday, that as of Monday, they are going to publish guidelines on what is called the public charge rule. It won't take effect on Monday. It takes effect 60 days after Monday. So that's like, what is that? July, August, September 20th, around that time frame. I want to make everyone clear. This rule does not apply to people who are obtaining their green card through the asylum process. Okay. So if you're currently receiving benefits and those benefits are essential for your health and your family's health and your safety and your financial security, and your pathway to a green card is through asylum, public charge doesn't apply. Public charge only applies to those people who are obtaining their green card through marriage to a United States citizen, or through a family petition, or through an employer petition. Doesn't apply to asylum. If you are a victim of a violent crime and obtaining a U visa green card, none of it applies to those things. So the first and foremost, most important thing is don't panic and dump all of your benefits that your family desperately needs because you think it applies to you. Speak with an attorney. Sometimes attorneys will just do a simple consultation on this issue and say, hey, can I continue using benefits? Is it safe for me? And an attorney can go through that process with you and tell you whether or not it is.
Can you tell us what who are considered a public charge, like someone receiving a food stamp, or if they are receiving benefits like to pay their rents through Section 8 or other available program? Do you know on top of your hands some kind of programs that are considered public charge?
This is the really bad news, is the way this new rule is written, the government can take almost everything into consideration, including Medicare and Medicaid. So again, I just want to stress, it's a very small number of people that the rule even applies to. The rule is clear that the government cannot apply it to asylum seekers. The rule is clear that the government cannot apply it to somebody who's got a U visa or trying to get a green card through a U visa. It's only to people getting their green cards through marriage. The new rule is very broadly written. It only applies to people. First of all, it doesn't apply to people who have already filed for their green card through marriage. So let's say you filed your green card application a couple of months ago. The rule doesn't retroactively apply to you. It only applies to people who have filed for adjustment of status after the 60th date has run. But it is broad in the way the government wrote it, in that they're applying it to all sorts of public benefits, housing benefits, multiple different types of benefits. I will also say that last time this rule was sued over, and it seems pretty likely that it will be again challenged in the courts by some organization.
So what we have seen, Susan, some employers in the Massachusetts, other states as well, they already laid off people who were working every time a decision is taken before the DHS put out a new guideline. So some people already lost their job right now, despite the governor's office put a statement saying that people are still eligible to work. What are some kind of remedies that those people have? Like, some say that I was working and then my employer laid me off, and then I go back, say, I have until July 24. That's what DHS said. Should they hire me? Do they have any obligation to rehire me to the job that I had before?
I mean, I'm not sure by the time you get back and get through the process that to be rehired that it would actually be effective. I do think that it is illegal for employers to prematurely terminate people. Our office has trained 800 potential employers or potential employers about the rule and about when they're allowed to terminate it. In addition to issuing the guidance, we are trying really hard to get the word out. I would say you could contact the Massachusetts Attorney General's office and file a complaint for discrimination for premature termination. I do think that, you're talking low damages legally because it's like a week or two early termination, but it is something you could challenge.
So is there any unemployment benefits available for people who has been laid off after their work permit, after the Supreme Court decision? Do they have access to state unemployment, things like that?
Unemployment is determined by the federal, it's controlled in large part by the federal government, the payment of unemployment. And unfortunately, the way we have looked at the rules is unemployment is available for those who have current work authorization. So the idea of unemployment is you are available to work, you can work, but right now you don't have a job. And unfortunately, if you don't have work authorization, it's difficult to get unemployment.
Let's go back, Susan, to the Supreme Court decision. I see there's a debate between lawyers and the Haitian community right now. Some say there's a possibility if the judge is in lower court, the appeal court, district court, has for more time to understand the Supreme Court decision so they can put their decision in line with what the Supreme Court say. So the TPS might be able to go over July 27. There are some other lawyers who say, nope, there's no such things. As soon as the Supreme Court release its ruling, it's done. There's nothing they can do unless the Supreme Court say they reverse their own decision. Well, you are an experienced lawyer, so you deal with cases like that before. What can you tell us? Can you clarify that for us, please?
I mean, unfortunately, I hate to be the person with bad news, but I do not think that the lower courts are going to do anything other than certify the judge's opinion and docket the opinion and put it into effect, which means that TPS is very likely to end on July 27th. However, there is a movement within Congress for essentially to get TPS reinstated by petition in Congress. There are employers who are starting to speak up because this is devastating to many employers, particularly in healthcare and related fields. We just know how important Haitians are to Massachusetts, to our hospitals, to our as personal care assistants. They work in all the industries in our state. So, and employers know this too. So there is certainly public pressure going on to try to get the federal government to reverse this opinion. And that seems to me the most likely pathway for anything to happen.
And then that's mean there's no possibility. So I'm not asking you that just to have you say things that you're not willing. I just want to make it clear for people so that they don't get false hope. Unless the government say, because there are some employers who contacted the Trump administration saying that they are going to lose a lot of employees right now if the decision take effect, just unless the government agree that they are going to give like 4, 6 months, whatever it is, it's not going to come through a lower court decision, say, we don't agree with the Supreme Court decision, so we need more time. So that's not something that can happen legally.
I mean, generally the Supreme Court speaks and the lower courts follow what the Supreme Court says. That's how our Constitution works. That's how our federal government works. It would be, I never want to say never, because in this day and age, we don't know how to predict things anymore, but I think it's highly unlikely that it would come, the relief would come through the courts.
So what can you share some resources in terms of people looking for counsel, legal advice? But the Trump administration, according to Miami Herald, they sent a letter to Haitian Prime Minister saying they need to expect at least two deportation flights a week. What can you tell us about what should someone know right now if they lost their TPS, when they lost their TPS status right now? What kind of protection do they have? Say someone who didn't file for asylum, didn't have anything at all. So we're going to come to that after. What should they know in order to protect themselves?
It's a great question. It is the most important thing anyone can do right now is to meet with a lawyer today. Don't wait till July 27th. Don't wait till 2 weeks after it. Find a lawyer today and decide, and a good lawyer, a reliable lawyer, not a lawyer from TikTok or WhatsApp or Instagram, please. Find that person today and find out if there's other pathways. The second thing you can do is be prepared. Family preparedness is a conversation that is honestly extremely painful to have, but many people own businesses. They've been here, they own cars, they own houses. All of those financial assets are very difficult to transfer if you are overseas. So make a plan for that. There are, in Massachusetts, we have power of attorneys that you can issue to someone you trust, someone who has legal status, maybe a citizen, that they could help you sell and transfer your assets if, unfortunately, you were removed from the country. So make a plan. Just making a plan doesn't mean it's going to happen. It means you're protected against it if it does happen.
And by family preparedness, so someone doesn't have to give their child an adoption in order to have protection. The power of attorney. Can you give us more detail about that? So is that something?
Absolutely, absolutely. And I'm glad you asked. And I can point you to I'll send you some resources that you can share with your viewers. Massachusetts has a number of written laws that protect people's children without having to do adoption. So the first and the most simplest form is called a caregiver affidavit. We have one on our website. If you go to ORI, the Office for Refugees and Immigrants, we have it in multiple languages, including Haitian Creole. That form just says that someone you trust can make educational and medical decisions about your children. That's it. Another thing you can do, and this is really key, is to get all of your children passports, both Haitian Creole passports, Haitian passports, and U.S. citizen passports if they were born here. So if they're born in the United States, they are U.S. citizens. That case at least was successful in the Supreme Court. Your children need both passports for both countries because they may want to come back to the United States one day. Financial assets can be taken care of by what's called a power of attorney. You can fill out this document with almost any lawyer will do this. This doesn't even need an immigration lawyer. And that just gives someone you trust the power to control your assets if you are deported. And if you get in a fight with that person, you say, I don't trust them anymore. You can rip up the document. It has no legal effect. So those are kind of three options for families that will do something to protect them in case the worst happens.
So say that I just have an agreement with my brother, say, in case I get to be deported, you take care of my kids. It's not in writing. Can my brother show up in school and then pick up my daughters and then say, okay, though we're good to go because we are related?
It's a great question. And generally that becomes a problem. We have been advising people since this administration took office to put whoever that person is, if it's your brother, put that person's name on the school pickup list, because they will not be the school will not allow that brother to pick up if there's no piece of paper authorizing them to be the pickup person. That's why, again, we strongly recommend the caregiver affidavit. If you get in a fight with your brother, you just rip it up. It doesn't mean your brother gets your children. It doesn't mean he gets to raise your children. It just protects your children in case something happens. Our government works on paper and evidence, right? We don't take oral agreements very seriously. It has to be written down. That's one of the fundamental parts of the American legal system. Write it down, do a caregiver affidavit, go to the ORI website and fill out the form.
And if someone has some assets, say houses, things, they don't have to sell their houses because they are going to be deported or they're going to leave the country. They can use the power of attorney and then have someone to take care of this, say that rent their house for them and then send them the money and then take whatever the fee, their agreement, like they agreed upon, but they can keep their asset while they are overseas. And then maybe 4 or 5, some years from now, they can come back and then get their things back. Is that something that is possible?
That is exactly about coming back or not coming back. That's a complicated question, but as having somebody manage your assets, yes, you can own property in the United States, even if you're overseas. But again, if you have not filled out that power of attorney ahead of time, how are you going to manage it? How are you going to bank? How are you going to hire contractors to do work on your house? No random people can't go and have your roof refinished, right? You have to show ownership over the property. So all of those things need to be put in place so that somebody you trust can manage the property.
Let's now talk, Susan, about people who apply for asylum. Would that prevent the government from putting them on a deportation flight? So say that I did not apply, and then now I say, I apply for asylum, and then I get, does that give me any protection right now?
So what asylum does is it gives you a pathway to a green card in front of an immigration judge, and it could give you a stronger argument for release on bond. It's not an unequivocal, like clear, no question protection against being put on a deportation flight. It just might give you some argument in court that you should be released on bond while your immigration case is playing out. It shows that you have you're not necessarily a flight risk because you have a pathway to a green card. It's a piece of the puzzle. It's not a guarantee.
Under what conditions, Suzanne, can someone be deported? Should they receive a notice of deportation first, or if in case they are arrested, can the government just take them, put them on a flight tomorrow, and then send back to their country?
So there's a small category of people that the government can, put on a flight. Those are people. The two categories of those people are, number one, somebody who has what's called a final order of removal. So this is an individual who has come to the United States. They've gone through all their court proceedings. Either they showed up at all their court proceedings, or if they missed a court proceeding, they've finished everything, their appeals are done, and they have no more hope. People actually can have TPS status and a final order of removal at the same time. Those individuals are at risk of being put on a plane and taken quickly, the final order of removal. The second category is the people who have been in the United States for less than 2 years. Those people are all also more at risk. But everybody else, generally, unless you came from Europe on what's called an Estes visa, which no one from Haiti has, generally you are entitled to your day in court. Now, this administration more and more is insisting that day in court be while you're held in jail, but you still get a hearing in front of a judge before you can be removed, unless you're in the first two categories, which is final order of removal or less than 2 years in the country.
So if someone has some, criminal records, or get into an accident at fault, would that allow the government to, fast track their deportation, so don't give them the due process, like the 2 years would not apply for them?
There is like a very small category of people who've been convicted of a crime called an aggravated felony that might be subject to a faster track, but that's very rare. A simple car accident, a simple driving without a license, what that would do is not fast track your removal, but make it more likely that you come into contact with ICE. So right now there is legislation preventing this, but every time anybody ever has contact with local police, this is federal law, the state can do nothing about this. If you have any contact with local police, you shoplifting, driving without a license, open container law, and you are brought to the police station and they take your fingerprints. Those fingerprints by federal law are transmitted to ICE. And that means that ICE knows that you have court in, let's say, Waltham District Court on Monday, and they often are waiting at court to pick people up. So now, there's a new law that's pending that might prevent them from picking up people inside the courthouse, but it could never prevent them from waiting out on the street, outside of the courthouse area to pick a person up.
So that's not the police being cooperating with ICE. It's how the system is working. As soon as you get your fingerprint, so the government is aware of that. That's not the police calling ICE, say, hey, we got someone, just come to get them. So there's no such cooperation with the police in Massachusetts.
I mean, I can't tell you what every single police department in the state does. I will say many, many police departments have a no cooperation rule, but they cannot control this fingerprint issue. If your fingerprints are taken, it goes to the federal government. The federal government immediately has access to it. I mean, we've even heard of cases where the fingerprints are taken and ICE is waiting outside of the police department before the person even goes to the jail. They have immediate access to that information. It goes very quickly into the federal system. So it's not that that the local police are calling ICE, it's that the electronic database is connected.
So what kind of advice, Suzanne, can you share with someone right now just to avoid, I know there's not absolute things. Before that, can ICE come to my, my house, my business, wherever I am right now, and then say they didn't have any deportation order for me, they didn't have any warrant, judge warrant, federal warrant for me, and then they just come and then pick someone inside? Because we see some video on TikTok, on other social platform, and people saying, hey, ICE trying to get people inside the house right now. Is that something that is legal? Is that something that is happening?
No, and we don't think that they are trying to get into people's houses much anymore at all. And I think a lot of that is due to the fact that the community has responded with a huge series of Know Your Rights presentations. And people are generally not opening the door for ICE because ICE has something. ICE is a civil law enforcement agency, meaning that they don't have the same powers as the local police do. And one of the biggest things they don't generally have is a judicial warrant. A judicial warrant is a warrant that is signed by a judge, issued by a court, and based on probable cause that's determined by like a neutral, detached person. What ICE does is they have a database of people who they're going to try to arrest that day, and they print out a document called an administrative warrant. They print this document out themselves. It's their own document. They sign it themselves. There's no significant review procedure. Because that's the type of warrant that they use, they're not allowed in people's homes, right? The courts have been very clear about this. ICE even understands this. And so generally they won't go inside people's homes. We are seeing people arrested in airports every day right now, every single day, flying domestically. So we used to say, don't fly international, don't leave the country if you have questions about your status. But today we are seeing people flying from Boston to Chicago, arrested in the airports. We are seeing ICE sit outside of people's homes at 5 o'clock in the morning and wait for them to go to work. And we are seeing people at people's workplaces, showing up at their workplaces. So those are kind of what we're seeing from ICE. ICE still is required to stay out of private spaces, and we expect that they'll continue to follow that rule.
So say now, I'm glad you shared those information with us. Say that someone, they knock on my door. Do I have the right not to open the door? Do they have the right to answer do I have any legal remedies because I'm undocumented? So do I have any legal protection for me from being abused by ICE?
Yes, you have a legal right not to open your door unless ICE shows you a judicial warrant. And the way you can tell it's a judicial warrant is it might use the word court on it. That's a judicial warrant. I can send you a sample warrant. It might use it will use the words defendant, but if it says the words DHS or Department of Homeland Security or ICE or alien, that means it's an administrative warrant and it's not a valid warrant to get into your home.
Is there any legal resources available for someone who is in ICE custody right now? So any line phone they can call, say they need some help because some people, they are not able to pay a defendant themselves, so they would like the state to help them. Is there any resources like that?
Yes, we have a lot of resources. So one of our first programs that we set up is an emergency legal representation fund. So for people who are detained, there's a hotline number. That number can be called, and we'll provide those resources to you. That number can be called from the jail, or it can be called by a family and friends. That will connect an immigrant with a lawyer who can try to file for bond or habeas petition, which will prevent your transfer out of the state immediately. We have the help desk that we previously spoke about, and we have the Massachusetts Access to Counsel initiative. All of these resources can be accessed by immigrants, particularly in an emergency situation.
Just to come back on the resources that were available for people who were working, if someone become undocumented, they lost their legal status, do they still have some resources? I mean, beside legal resources, the state put available for them. Like, I'm not inviting you to come to talk about housing, food, things like that. Do they still have some benefits they can have, which is not legal, a benefit they can have from the state, despite they lost their legal status?
There are some resources. This administration has done a lot of work to try to limit those resources. But if you go to the Housing and Livable Communities website, there might be funding available through RAFT, which is for emergency eviction protection. There is still, Haitians in particular enter the United States under a status called Cuban Haitian entrance. So that allows them to remain eligible for many benefits, including emergency shelter assistance and SNAP benefits. So I encourage you to reach out to the Department of Transitional Assistance or Housing and Livable Communities if you and your family need emergency assistance.
Is there anything you think it is very important, Susan, that I did not ask you and you think our viewers should know in this context right now, given the expiration of TPS coming very soon?
Yeah, I think a lot of people are still hoping for a miracle, and there's nothing wrong with that. Keep hoping for a miracle. We all know what a horrible economic and emotional blow this is to your families and to our state, to be honest with you. But prepare. You can do both. You can hope for a miracle, but prepare for the worst. And I would just urge people to do both.
Can you just remind us when you say prepare, so what kind of preparation they can do in terms of like family preparedness, power of attorney, and things that are not very difficult for them to do, but will be difficult if in case they are arrested and then they are not available to sign anything?
Exactly. And get a good lawyer now. If you have not met with a good lawyer, you've just been renewing your TPS all these years and you didn't think you'd ever need it, now's the time to get a good lawyer.
Thank you so much, Susan. It was a pleasure to have you.
Thank you so much.
Thank you. Bye-bye.